Good morning to you. In continuation of our earlier discussion on Constitution and Indian polity, today we will take up fundamental rights. The first article is Article 12. This article defines state. Wherever the term state comes, you should apply the definition given in Article 12. This definition in Article 12 applies not only for Part 3, that is fundamental rights, but also for Part 4, that is directive principles. So, the definition state given in Article 2 is common for both fundamental rights and directive principles. Now, the definition says that the term state includes union legislature, state legislatures, union executive, state executives, local authorities, and other authorities within the territory of India, and also local authorities and other authorities under the government of India. There was a question whether the term state includes judiciary also. Yes, in 1988, Supreme Court clarified in Antule versus Nayak case that the term state includes judiciary also. But you cannot issue a writ petition under Article 32 against the Supreme Court. Remember. So, you have seen what is the definition given for state in Article 12. Now we are coming to the next article, that is Article 13. Article 13 is, as you know, is judicial review taken from US Constitution. What is the purpose? Purpose of Article 13 is to secure primacy of the Constitution, especially with reference to the fundamental rights. The powers of the judicial review had been given to the Supreme Court under Article 32 and to High Court under Article 226. What does Article 13 say? Article 13 says that the state shall not make any law which it takes away or abridges any of the rights conferred in Part 3 of the Constitution, and if any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, remember, to the extent of repugnancy, that is inconsistency, is null and void. You may recall when we discussed doctrine of severability, I said the same thing. To the extent of inconsistency, the law which violates the fundamental rights is null and void. This is the decision of the, this is the addition in the Article 13. This is the nutshell, the meaning of Article 13. Now remember, 24th Amendment Act 1971 added a clause under Article 13 stating that the article does not apply to any constitutional amendment made through Article 368. This was added by Mrs. Indira Gandhi to protect, to insulate the decision of Supreme Court in the Golaknath case. But Kesavananda Bharati versus State of Kerala case, Supreme Court nullified this amendment. So, remember, this amendment is not there. Now, the Article 13 has very important provision. That is, number one, it defines what is state. What is law. State has been defined in Article 12. But Article 13 defines the law also. Law includes, according to the note given under Article 13, the law, inverted quote, law includes ordinance, act, regulation, rule, instruction, customs, and usage, or any order which has the force of law. So remember, the law has also been included, defined in Article 13. Now we are coming to right to equality. That is, we have seen Article 12 and Article 13. Now 14 onwards. Now remember, first set of right is right to equality, which includes Article 14, 15, 16, 17 and 18. Remember, this Article 14 prohibits discrimination in a general way, and it guarantees equality before law and equal protection of law. However, since certain amount of indefiniteness has been attached to the general principle of equality given in Article 14, separate provisions have been made to cover specific discriminating situation. So, Article 15 says, that is, Article 15 prohibits discrimination against any citizen on the ground of religion, race, caste, sex, or place of birth. In short, remember, I already told you RRCSP. This is Article 15. Because Article 14 is general in nature. So, how can you specify this? So, specifically, Article 15, prohibition of discrimination on the ground of religion, race, caste, sex, or place of birth. Then Article 16 guarantees equality of opportunity in public employment and public appointment under the state. Remember, Article 14 general in nature, Article 15 clear prohibition against discrimination on the ground of RRCSP. After Article 16 is equality of opportunity in public employment and public appointment under the state. Then Article 17 abolishes untouchability. Article 18 abolishes titles, except for academic and military distinctions. Remember, when we say right to equality, you should remember all the 14, 15, 16, 17 and 18. When we say equality clause, remember, it is only Article 14. So, if there is a question about right to, what are the articles governed under governed under right to equality, you should remember all the 5 articles, 14, 15, 16, 17, 18. Whereas, right to equality, under a right to equality, equality before law means Article 14. You should remember. Now we are coming to what exactly Article 14 says. Article 14 says that the state shall not deny to any person equality before law or equal protection of law. Remember, very categorical, one out of line. Article says that the state shall not deny to any person equality before law or equal protection of law. See, the state shall not deny to any person. Remember, this is applicable, available to both citizens and non-citizens, including foreigners, including companies, including corporates. The state shall not deny, negative in character. Remember, negative in character. The state shall not deny, it is injunction on the state, don't do it. So, all the 3 points, remember, it is available to citizens and non-citizens. Number 1, it is an injunction on the state. Number 2, it is negative in character. Number 3. Secondly, it has 2 components. One is equality before law and another is equal protection of law. Equality before law is English origin. Equal protection of law is American origin. So, what is equality before law? First, we will see what, equality before law. What does it mean? Right from the Prime Minister to the chaprasi, all are equal in the eyes of law. This is a nutshell. Howsoever you are tall, law is taller than you. Everybody is subjected to same law. There is no discrimination. It is based on A.V. Dicey's rule of law. What does it mean, rule of law? And the rule of law, remember, it is very important component, that is Dicey. That is, a man can be punished only for breach of law and for not for anything else. A person can be punished only for breach of law, number 1. Number 2, equality before law. No one is above law. I have already told you, howsoever you are tall, law is taller than you. Number 3, Constitution is supreme. Howsoever the other provisions are there, law is made. Constitution is the supreme law of land. These are all the 3 principles imbibed in the principle of rule of law. Remember, rule of law is the basic structure. Remember, earlier it is the law. Yes, king is the law. Original concept is king is the law. It has been converted into, that concept has been converted into law is the king. Law is the king. So remember, right to equality contains all the 14, 15, 16, 17 and 18. Now we are seeing Article 14. It has 2 components, equality before law and equal protection of law. Equality before law is of English origin. Equal protection of law is American origin. This equality before law is based on A.V. Dicey's rule of law. It has 3 provisions. That is, every person can be punished only for a breach of law in force at the time of commission of the act. Number 1. Number 2, no person is above law. All are subjected to same law. Number 3, Constitution is the supreme law of land. Now the question is whether this equality before law is absolute. Whether there are any exceptions. Yes, there are exceptions. What are the exceptions? Number 1, President of India or Governor is not answerable before any court of law for any act done or purported to have done in exercise of his powers during the term of his office. Article 361. This is the immunity given to President and Governor. Number 1. Number 2, no process of arrest can be initiated against the President or Governor in respect of any act done or purported to have done in exercise of his powers during the term of his office. Number 2. Number 3, no criminal proceedings can be initiated or continued against a President or Governor during the term of his office. Number 5, no civil proceedings can be initiated against the President or Governor during the term of his office which he had committed in a civil capacity, no civil proceedings, civil capacity, before entry into the office or after entry into the office, except after giving 2 months notice. Remember, 2 months notice. Secondly, under Article 105 of the Constitution, no member of Parliament can be subjected to any proceedings for anything said or any vote given in Parliament or in any parliamentary committee under Article 105, and for state legislatures, MLAs and other people, it is 194. So 105 protects the MPs and MLAs respectively in 194 that they cannot be subjected to any proceedings in any court of law for anything said within the parliament or any vote given in the committees. Remember, secondly, another is no person can be subjected to any proceedings for publication of the true version of the proceedings of parliament. Suppose I produce the proceedings of parliament in a publication, I cannot be prosecuted for that because once it has been published, unless the secret proceedings, once it is published, it becomes the public domain, it becomes the public property. So, the parliament, unless prohibits specifically, if I have reproduced the same true version of the proceedings of the parliament, I get the immunity. So, remember now, another is most important, which I have already explained while we discussed this, what is known as fundamental rights. There are certain exceptions. Article 31A, 31B, 31C. And Article 31A added through First Amendment Act 1951 by Pandit Jawaharlal Nehru. It says abolition of zamindari system or agrarian reforms. If any law is made to implement the agrarian reforms or abolition of zamindari system, that law cannot be questioned in any court of law, even if it violates Article 14, Article 19 and Article 31, which has since been deleted. This is Article 31A, remember. Second is Article 31B. This is also added through First Amendment Act 1951 along with Schedule 9, which provides judicial immunity for all the acts which have been included in the 9th schedule. Tamil Nadu Reservation Act, which has provided 69% reservation, is one of the acts which have been included in Schedule 9. It is incidental. Under this, if any law is made to implement the land reforms, that law cannot be questioned in any court of law, even if it violates Article 14, 19 and 31, which has since been deleted. Then Article 31C, added through 25th Amendment Act 1971 by Mrs. Indira Gandhi to give protection to Article 39B and C, which is to enforce the socialistic principles. So, if any law is made to implement the principles given in Article 39B and C of directive principles, that law cannot be questioned in any court of law, even if it violates Article 14, 19 and 31 since deleted. Remember, that is why we say when Article 31C comes, Article 14 goes out. They cannot see together because Article 31C protects Article 39B and C, whereas against the Article 14, 19 and 31. So, that is the 3, 31A, 31B, 31C. Next, under the international community, the diplomats, foreign sovereigns, ambassadors enjoy immunity. Remember, they enjoy immunity. They are not subjected to any judicial process. And above all, remember, and above all, fundamental duties is another exception to Article 14. Fundamental duties, another exception to Article 14. If there is a clash between fundamental right of Article 14 and fundamental duty, the fundamental duty will prevail over the fundamental right because the individual interest should be subservient to the society's interest. I have the liberty to do anything till it touches the tip of your nose. My liberty, which the right to enjoy the freedom, is also restricted, monitored, reconciled by similar desires of other people. I have every liberty, provided it does not encroach upon the interest of the society. That is the interpretation given by Supreme Court while upholding fundamental duty over and above the fundamental right. So we have seen Article 12, Article 13 and Article 14. Now under Article 14 still we have got one element, that is equal protection of law, which we will see in the next class. Thank you very much.